From college campuses to deportation courts, the legal system is grappling with a presidency divorced from norms of conduct and deference. Here to talk about it is Nick Allard, founding dean of the Jacksonville University College of Law and a veteran of the Washington, D.C. political world. Good morning, Nick.
Good morning, Ann. Thanks for having us.
Thank you for being here. We're also joined by Bryan Gowdy, a board certified appellate attorney who has argued orally before and briefed the U.S. Supreme Court on several cases. Good morning, Bryan.
Good morning, Ann. Thank you for having me.
Thank you for being here. Nick, there are now upwards of 180 lawsuits that have been brought against the Trump administration in the nearly 12 weeks of his second term. And there's obviously a lot of different targets on these cases. But do you see an overarching theme of any kind?
Well, I do, sadly. And first of all, I'm just so grateful to be able to be here and to speak up uh, with my own views that are independent of any organization or other group and just be able to express because of the country we live in and have the freedom to state my beliefs, give my analysis, and even be wrong. So that's very good. But there's a theme, and it seems to be, and I'm sad to say this, but it's a theme about dismantling constitutional guardrails that have long protected us and served us well. And so we're focusing today, talk about lower back pain. I've got a very lower back pain from what's been going on. But, but we're just focusing on the aspect of attacking the rule of law and people who represent folks in our adversarial uh, system, which is built to be adversarial by legal experts who act on behalf of clients vigorously and within the rules, the legal rules, and also intimidating and attacking judges who are the independent, need to be independent. And so if you remove those guardrails, some of the most important protections of the American people are removed. And so that's what's at stake right now.
And Bryan Gowdy, to Nick's point, there's a lot of issues, and we'll get to some of them in terms of the legal challenges and the arguments that are being made. But the treatment of judges is a singular issue that does seem to be somewhat unique to this administration in terms of um, calling for the impeachment of judges who've ruled against the president, suggesting that on his own social media that the courts are basically powerless to tell him what to do, saying, he who saves his country does not violate any law. So, can you kind of contextualize what those comments, how they maybe differ from what we've seen in the past, and what their significance is, if any?
Yeah, their significance is that we have three branches of government, and there's one branch that doesn't have any army and doesn't control the purse strings, and it depends wholly on respect that their orders will be followed. I think I had shared to you, Ann, that I recently heard Judge Shoflat, who's been a federal judge for more than 50 years,
Here.
here in Jacksonville, who
Great man.
presided over the school desegregation cases. He spoke about that time period where when I was very, very, very little, and don't remember it myself, but that he knew that despite the very contentious nature of the litigation, that his orders would be followed. And I think that personal attacks on the judges, like we've seen from the administration directed at Chief Judge Boasberg, the chief judge for the District of Columbia, are completely unwarranted and need to stop. Uh, and I saw a lot of statements by the administration that somehow, he was this liberal,
Radical
over the board,
left-wing
right, judge.
lunatic.
The basis on which the Supreme Court reversed him was very narrow.
And we should say this is the deportation case that is
Right.
at issue. This is the judge.
This deals with the case where the administration was deporting alleged members of a Venezuelan gang to El Salvador, and it happened very, very quickly over a weekend. And there was a temporary restraining order entered by Chief Judge Boasberg. And what the Supreme Court unanimously has agreed that each of these individuals is entitled to due process. It was not a significant victory for the administration, despite their public statements since then.
At the Supreme Court level.
Right. What the victory was where should those challenges take place? And Um, I read there was 9 justices, uh, and then there were 3 judges at the D.C. Court of Appeals, including one, relatively conservative judge. They all agreed that the administration has to give these immigrants due process. The question simply was where. And I think, for the administration to attack Chief Judge Boasberg, all 14 judges
Agree.
agree that these individuals are entitled to due process before they're deported.
And his order was essentially disregarded, right, in terms of, don't these people shouldn't be sent back, and then when they were in the air saying they need to be brought back, and, um
Yeah, the administration took the position that because the order was only oral, it didn't have to be followed. And I don't think anybody who's practiced law or been involved in the court system would agree with that. I've never heard of anybody saying that I can disregard the judge's order unless and until it's put down in writing.
I mean, walk us through what might happen. I mean, I if you said to a judge, "Hey, judge, you didn't put that in writing. I don't need to follow that directive."
I mean, the system would break down. Lawyers, I don't think the lawyers would be, probably not able to practice law if that was the position we took. I mean, the reality is that when you're in these type of cases, things are moving very fast. Uh, you can't get everything down in writing quickly. But if the judge says it orally, you have a transcript, it's on the record. It's part of the system. So I agree with Nick that the attacks on the judges have to stop. As far as how we got here, I would say I think the attacks on the judges are. I mean, it's fine to criticize a judge's decision or reasoning, and I think that's novel. I think the bigger picture of why we got here, really, you could look at both, Democratic and Republican administrations in the past. There's just been, I think, over the last, I don't know, 85 years, this slow creep of the executive branch taking more and more power away from Congress, and Congress, frankly, not asserting its own power. And some of these cases we can talk about it in detail, but there's just these statutes that are very broadly worded, and it gives an opening for uh, either administration to any administration to come forward and walk right up to the line or go past the line and try to assert that things can be done with executive power that really should be going through Congress.
And Nick, you were sort of alluding or mentioning how the administration and its allies have characterized the judge in this particular case, calling him a lunatic. But we know that, his AG Pam Bondi and his border czar Tom Homan have also said this judge has no authority. We don't care what he says. I mean, essentially saying he has no business telling us what to do in this case. And it does seem that that disregard could lead to just open defiance.
Chaos,
Mm.
chaos, and a constitutional crisis. So I agree, and also I agree with everything that Brian was saying. And the vice president has explicitly, who supposedly has a law degree from a very fine institution in New Haven, um, has said point blank that, which is wrong, that the president doesn't have to obey court orders. At least that's the way I heard it.
Yeah, he
And
said, quote, "Judges aren't allowed to control the executive's legitimate power."
and that is wrong. And the importance of this is that one of the responsibilities of America, of lawyers in America and legal educators is to help not only educate their students and each other, but the public about how our government's supposed to work. So when somebody in the public hears that the vice president of the United States, who has a law degree, says that, it's up to everybody else to help correct that and to demonstrate that that's simply not correct. But I can understand how people might be misled by that. It's unfortunate, and he ought to know better. But we would have chaos if judicial orders, they can be, there's a process, as Chief Justice Roberts has said when he weighed in about the intimidation of judges, and I think the criticism, I think it was of Judge Boasberg. He said, you have a process. If you don't disagree with a judge, you can complain about it, but there's a legal process and to follow, and that's the way that we should proceed, is through the legal process and procedures. Our Constitution, the rule of law, can be boiled down to this: it gives us the right to live in peace and harmony and prosper and be different and to disagree. We have this wonderful right to be different and to disagree peacefully while we progress and try to be a better, more perfect union.
So, what is a constitutional crisis? We hear a lot about, we could have a constitutional crisis if judge's authority is disregarded. And it has been in these cases, in some of them so far. There has been this expression of open defiance. At what point does it become a constitutional crisis? Does it have to be defying the Supreme Court as opposed to federal, district court judges?
Well, we're not there yet, and I have to believe that our beautiful, cantilevered, constitutional, self-correcting system of limited government will prevail. But we can see the end. We can see the chaos from here. And the crisis will come if, um, for example, is judicial process that concludes that the government is wrong, and then it just overlooks it. Um, it is not up to just the courts to sustain, to be the only institution that backstops our Constitution. Now, right now, the United States Congress, and forgive me for saying this, but I don't think I get much disagreement on this, is supine and prone at the same time, which is quite a maneuver, a gymnastic maneuver. So that is why so many lawyers and educators and retired judges and civic groups are speaking up now. And so I predict that will grow, not diminish, and the public will join them.
If you're just joining us, we are talking about some of the conflicts between the current administration and the Constitution. We're talking with two legal experts, and we will take your calls and questions. If you have them, you can give us a call at 904-549-2937. You can email First Coast Connect at wjct.org, or you can reach out on Facebook, Instagram, or X at FCC On Air. We do have an email from Tammy, and she's asking kind of specific to the issue of deportations. Could you talk about the difference between deportation and rendition? And as a second question, would rendition to a foreign prison be a violation of the Eighth Amendment under the prohibition of cruel and unusual punishment? I've heard both of those terms used here and there to describe what's happening by these roundups and deportations. Can you kind of provide some clarity of what the distinction is there?
I'm not an expert on that distinction, so I don't want to weigh in on what that term rendition is being used. I would just say, generally speaking, um, uh, those who are not citizens are subject to the immigration laws, and there are, as we were discussing, there are some statutes that give the president and the executive branch pretty broad authority for deporting people. And so I think what's happening really here is that these statutes, you know, uh, some of whom are very old, one from 1798, have never been used this way before.
And that's the Alien Enemies Act you're referencing.
Right. So, and I think what's happening is that the executive branch right now is really pushing the outer boundaries, if not going beyond the outer boundaries of what these statutes say. And of course, they're entitled to make their arguments in court. What they're not entitled to do is disregard the courts, because that would lead to the
I
constitutional
might be able
crisis.
to cast a little light on Tammy's question. And by the way, Tammy, if you don't have a law degree, we'd love to have you at the Jacksonville University College of Law, because
Always recruiting.
those are two great questions: the difference between rendition and deportation, and then this concept, which I don't see any of the brainiest lawyers in the United States have yet raised, but you point out, is that the Eighth Amendment prohibits cruel and unusual punishment. And if we are sending people who have U.S. rights to a foreign prison that arguably is cruel and unusual because it doesn't meet our standards, that's another argument. So well done, Tammy, for raising that question. So rendition is typically associated with covert, dangerous. It's removal from the United States covertly of people who pose, based on, even in that instance, some judicial review, but to send them to a less protective jurisdiction outside of the United States for interrogation and
Mm.
so on. So that's commonly the case. So if you expand that broadly, our rights not to be snatched off the streets and then sent somewhere else, if you're using rendition, it's supposed to be a very narrow um, process. It's not one where you see, well, we want to get out of this country a million people. That's not what it's for. And no one wants dangerous terrorists in this country. Nobody wants criminals who are illegally here in this country. This is about something else, much broader, and the courts and laws are there to protect Americans, and we protect the least advantaged, and sometimes we protect the rights of people who are bad, so that they are justly accused and processed, and that protects us. Because if we don't protect the littlest, the weakest, and the worst of us, we're not protecting ourselves.
We have a call from Les on the west side. Good morning, Les. Go ahead.
Good morning. Great show. I would like to ask if your group, your panel there, believe that the president is operating on his own knowledge of the law, or do you feel that he's being counseled by others? Thank you.
Thanks, Les. Your thoughts?
No, he clearly has counsel. I mean, he has the White House counsel. He has a lot of lawyers at the Justice Department. I think, uh, one thing clients can do, including the president, is you just you keep changing lawyers till you find the one that gives you the answer you want. Um, and I think there has been uh, some of the lawyers within the Justice Department, have tried to correct things. We were just discussing a moment ago, uh, the situation with Chief Judge Boasberg. Originally, the administration seemed to be taking the viewpoint that they could do what is called rendition, which is just remove somebody from the process, as Nick was describing, from the country without due process. By the time that case got to the Supreme Court, though, the government had conceded that it needed to give due process. So it seemed like at some point some lawyers weighed in with that. But we can't know. We don't know what legal advice the president is getting. That's privilege, but he's getting legal advice. I don't think he's doing these things on his own, but he's obviously getting probably the legal advice he wants.
Well, we do
In
know that, in the case of Kilmar Abrego Garcia, who's the Maryland father that was deported to El Salvador, that the judge in that case, the same judge, had asked the d- the president or his lawyers, why the federal government couldn't bring him back from this prison, and the attorney said to the judge, I don't know. My client hasn't given me a reasonable answer, and then was subsequently removed from the case. And so there are attorneys representing the president that may not necessarily be on the same page always with him, Nick.
Yeah,
Oh,
and before Nick, I just want to weigh in on that real quickly. I think we talked about the constitutional crisis. One, I think, very encouraging sign, or I should say a encouraging sign, is President Trump on Friday was asked about the unanimous Supreme Court decision affirming the Maryland judge's order requiring the administration to facilitate the return of that individual from El Salvador, and he said he would respect the decision. Um, I think the administration needs to do that for every judge, not just when it's 9 justices. But Nick, you want to weigh in?
well, I think you really hit the nail on the head there. The Who knows what goes on in the president's mind, but he was reputed and notorious, or I guess I use a less pejorative term. He was well known to disregard advice of his counsel and do go through the process that Brian was just describing about finding counsel. And now this is concerning, is that there are directives out, including issued by the Attorney General of the United States, which is quite extraordinary, unprecedented, that nobody at the Justice Department or other people are supposed to disagree or criticize or have an independent opinion.
Mhm.
And so I think there's an intimidation internally of attorneys who are both inside the government operating. And an example was that the attorney who appeared before the court Chief Judge Boasberg and explained the truth that he didn't have an answer and that he couldn't explain what had happened, he was fired.
Mhm.
So there are consequences, and it's not dissent and disagreement and vigorous debate are not comfortable, they're time consuming, and sometimes they're unwanted, but they're healthy and they're useful to get to the right answer.
We've got an email from Ross, and he says Trump is not the first to act this way towards the judiciary. He's just following the precedent set by those before him. FDR intimidated the Supreme Court into backing down by threatening to pack the court. He writes Obama spoke fondly of his pen and phone. Americans seem to like the imperial presidency, and Trump recognizes that, which is why he acts like a king. That was something you were sort of getting at a minute ago, Brian.
Yeah, I think that's I wouldn't say Trump's identical to these presidents that were just mentioned or any other. I think he is unique in a lot of ways, but he's not unique that, really since the time of FDR, the president and the executive branch has gotten more and more powerful, and we as Americans have allowed that, and the Congress has allowed that. I mean, just as an example, from the last 2 Democratic administrations, there's a big problem, obviously, with the Dreamers under immigration. But rather than get a congressional solution, because that seemed to be too difficult, we had an executive order. And then, in the last administration, there's a problem with student loan debt, a big problem. But rather than get a congressional solution to that, we had an executive order.
Mhm.
And this may seem way off topic, but it's for those of you that are sports fans, there's lots of problems right now with amateur athletics in the NCAA. But rather than get a solution from Congress on that, we don't have an executive order. We have a lawsuit solving it. So I think really a lot of this boils down to Congress in the last 80, 90 years hasn't done what it was designed to do, which is make the law.
I
Sadly, it's dysfunctional.
Mhm.
It really is. But I'll tell you one thing in terms of, first of all, FDR's court packing scheme was one of the greatest failures of his 4 terms and did not succeed, and he paid a sharp political price for it. But the other thing is, Mrs. Allard, my mother, um,
Mhm.
always hammered into our heads that 2 wrongs don't make a right, right? So just because it's been done before doesn't make it right, and we're now in a place where we continue to work together, hopefully collaboratively, towards a more perfect union. We can decide with our own eyes what's the way to go, and I think that, the rule of law and the Constitution provides the guardrails that have kept us together as a very, in very difficult, changing times.
I want to ask a little bit about we've been talking about the president's actions and attitudes towards the court judges, but there have also been these series of actions recently taken about towards against lawyers and law firms, which has been commanding some headlines recently because it is so unusual. These are law firms that have in many cases fought the administration on one case or another, have earned the president's ire, and so are now being targeted and sort of forced into these agreements with the president in order to make these executive orders go away.
And
Um,
and some preemptively sought the agreements. So there's 9 of the largest, most prestigious, wealthiest law firms that have reportedly, because we haven't really seen the details, worked out an agreement to avoid the harsh retaliatory penalties that would have been imposed otherwise, or investigations. But 3 have drawn a line and are litigating. And their litigation, Perkins Coie, a very old, prestigious, highly respected firm, was singled out and was the first firm to get an harsh executive retaliatory order. And that
and
was
what are these orders based on? I mean, is the president alleging something illegal? Is he alleging that they have violated their oath or the law in some way? Or what is the legal justification for saying that he's going to take their security clearances, he's going to penalize them if they don't sort of change their ways or satisfy him?
well, I should say that from my reading, this is my personal opinion, but a lot of people share this view. there is no constitutional or statutory basis whatsoever, and there's no evidence presented. And in fact, one of the fatal defects of the executive orders, again, in my opinion, is there's just assertions, and the explicit rationale is for disfavor, political views expressed, representing clients that you don't like, in some cases, accused of being racially biased. These firms are probably the furthest thing from that you can imagine, but it's basically because of asserted DEI policies, which is a hot button. So the three cases that were brought in record time, in two cases on the same day, a temporary restraining order nullifying the effective date of these orders, was obtained by the courts. So, yeah, it's really kind of a remarkable, unprecedented action. Now, am I surprised by these big firms taking this action? Uh,
Caving, you mean?
Caving.
Well, explain to us, I mean, what are they thinking of? Why would they, as opposed to fighting as as some firms have decided to do, why are they deciding to, and we should say they're offering, huge sums of money, hundreds of millions of
$1 billion
dollars,
total now, almost 940, as far as we know, $1 million
and
of
that's
free
money
legal.
that's gonna basically go to support President Trump's favored causes or legal battles.
Well, it's a cynical misappropriation of the term pro bono, publico pro bono work, because that is the work, and Brian has been a champion of that work in legal services. Um, Lawyers have an obligation. Florida was one of the leaders, one of the leaders in the United States for lawyers meeting their obligations, not just to do well, but to do good. And they have an obligation to report. It's not mandatory in Florida, but Florida has been right out there in the expectation that we devote free legal services or discounted legal services not to wealthy people or organization, and not for business promotion or to protect your business, but to people who are less advantaged or organizations that can't afford it. So that's what it's for. It's not for, this is not pro bono work to give the government or one political leader free legal services as he directs for or she directs for their own purpose. So,
But so why are they doing
well,
it?
it's because these are the big firms. There's 500 plus firms that aren't quite as big that have, and some large firms which have signed an amicus brief that's been drafted. But there could be two alternative stories to why they're agreeing, in my view. One is that the big firms are big businesses. And so, like sometimes maybe the press, sadly, the old separation between the business function and the journalistic function, that line has now, evaporated. So law firms are making decisions based on their big business, and they want to avoid and put the problem, which would completely debilitate them and possibly put it out of business. On the other hand, they may realize, why not sign this order because it's unenforceable. Uh, the other folks are going to prevail in court. Every paragraph of the order ends with, to the extent permissible by law, and none of it's permissible by law, in my view. They may have taken that point of view, and it may be so ambiguous. They may be in a position to say, well, you're asking us to do something we cannot do because it's not consistent with our professional obligations and so on. So it could be everything or it could be nothing at all, and either of those two options. Neither of them are attractive because I believe if they stood up, the fundamental question that was implicit when in what you asked me, Ann, was why would somebody who has a tough case and needs vigorous defense hire a firm that can't defend itself in a tough case?
Mm.
So it's not really in the long term. And then also, why would the best and the brightest people want to work for a firm like that? So it's going to be a big question on how this all plays out, and it could have a big impact on the future of the legal profession.
Brian, one thing that this does is it also opens up potential sanctions against individual lawyers. I mean, this initial one is saying, that the AG and the president can see if sanctions are warranted and kind of file a motion to see if sanctions are warranted. But the end of that same executive directive basically says that in the future, if the attorney general determines that conduct warrants sanctions or other disciplinary actions, they can basically begin the process to remove a security clearance or terminate federal contracts. So it isn't necessarily an inquiry that would begin. It'd be a decision that could be made almost unilaterally if the actions of an attorney or a law firm displeased them.
Yeah, I think so. A few minutes ago, we had somebody email in and say like, "Oh, all the prior presidents have done this," but this is something no prior president has done that I am aware of, and I think these executive orders, like I'm reading the one on my screen right now with the Perkins Coie firm. They're the most dangerous aspect of what the administration is doing because they seem to they're just, if you read the orders, they're just vindictive. They're just targeting someone who, I mean, Perkins Coie, the orders clearly because they represented Hillary Clinton and that was Donald Trump's political opponent. And so to me, this is the most dangerous aspect of what is going on. Um, and I think it's a new problem, different than all the other ones we've discussed this morning, which are the ones we've discussed are generally the executive branch kind of pushing the limits of its authorities. But going after, private businesses, individual law firms, um, uh, I think something that should alarm all Americans. And as far as in the legal profession, um, you know, as Nick alluded to, um, we have a duty to represent our clients, even in very unpopular causes. Right? It's not popular to represent somebody on death row. It's not. It's not popular to represent someone who has speech that all of us may disagree with and that we all find despicable. But when lawyers do that, they're protecting all of our rights because at some point you will be in that minority. Um, and I think trying to attack lawyers simply because they took positions opposite you is probably the most dangerous thing that the administration is doing right now.
Yeah,
If
the
you
language itself says that they can seek sanctions for attorneys and law firms that engage, quote, "in vexatious litigation." I mean, it's hard to
We're
imagine
supposed to
anybody
be
who's being sued,
vexatious.
right? I mean, that kind of is the nature of
Yeah.
uh, an adversarial system, probably
Yeah, well, I
vexatious.
mean, and clearly, I mean, I would say, look, lawyers don't file. We're obligated not to file frivolous lawsuits, of course. But that's not the way I read these orders. That's not what they're going against. They're really disagreeing with the what w- with good faith litigation or even non litigation activities by the lawyer. It's viewpoint discrimination at
Brian,
the end of the day.
another point is that all of the alleged gripes were previously litigated,
Right.
um, and lost, all of them, in the courts. So it's been adjudged by courts, which is if you have a dispute, you have a complaint, that's the proper place to go. And so now they're taking another crack at it. This reminds me of like the reason that inspired me as an 11-year-old kid to want to become a lawyer was watching To Kill a Mockingbird at the drive-in movie. I mean, I still can barely remember that moment when the light went on for me when Atticus Finch took the case, the really unpopular case of defending the black man who was wrongly accused of raping a white woman. And he took that case. He lost the case. But when he walked out of the courtroom and his children were sitting up in the gallery with the black pastor, and the black pastor said, "Stand up, Scout." That was his daughter's name. "Your father's passing." The thought of being a lawyer and trying to make a difference in a difficult case, that's what motivated a lot of people
Hmm.
to become a lawyer. And so we're getting away from that if we let this slide, and I don't think we can.
Yeah, I just like to reiterate what Nick's talking about. I mean, these days we may look back at at some court decisions and we all agree with them. For example, Brown versus Board of Education, which desegregated the schools. But you have to remember at the time, the lawyers who brought those cases were very unpopular.
Mhm.
And if you read about when Thurgood Marshall came to the South and had to litigate and the dangers he and the other lawyers that were with him faced. But those dangers were coming from individuals. When you read this executive order, I mean, it's the same type attitude that that resisted for the desegregation litigation, but it's actually in the president's executive order. I mean, if you think back about that period of history, which I think we should all remember, the only reason we were able to desegregate the schools was because the executive branch, President Eisenhower, supported the federal judiciary.
Mhm.
Can I make one more point about these executive orders?
Just briefly, because we're going to have to wrap.
Okay, the language. If you look at other presidential, they're not presidential, they're petulant. You could look at the orders of Madison, Ulysses S. Grant, Nixon, Reagan, Bush. They're presidential, and these are schoolyard bully kind of language, and they're poorly written.
Well, we've got callers on the line and pages of questions, but we're going to have to leave it there. Nick Allard and Bryan Gowdy, thank you so much for being here today. Really
Thank you.
appreciate
Next
it.
time.
All right.
Thank you very much.